she's so fine. Hell of a hell of a blows my mind. Hell of a lights my...
What's good, guys? This story is coming out of Minnesota. It came out on the 27th of March. It was updated on the 28th of March. And again, it's courtesy of Marie 722. Minnesota Supreme Court throws out rape conviction because intoxicated woman willingly consumed alcohol. The Minnesota Supreme Court ruled that a person can't be found guilty of sexually assaulting someone who is mentally incapacitated due to intoxication if that person became intoxicated by voluntarily ingesting drugs or alcohol. The ruling was released Wednesday after the case of Francois Manulu Khalil, who was convicted of a third-degree criminal sexual misconduct by a jury because the victim was drunk and mentally incapacitated. Khalil, a Minneapolis man, met his victim after she was denied entry to a bar for being too intoxicated. The court's unanimous decision was written by Minnesota Supreme Court Justice Pale Thyssen. Thyssen writes that the lower court's definition of mentally incapacitated regarding the case, quote, unreasonably strains and stretches the plain text of the statute, end quote, since the victim was intoxicated before she met Khalil, her attacker. In order to be considered mentally incapacitated under Minnesota law, the alcohol must be given to the person without that person's agreement, according to the court. Because the original case did not meet the standard for a victim to be mentally incapacitated, the state's high court granted a new trial for Khalil. Many are concerned about the consequences of this ruling, including Kelly Mahler, a Democratic state representative from Minnesota. Victims who are intoxicated to the degree that they are unable to give consent are entitled to justice. Minnesotans who experience unthinkable trauma deserve to see the legislature take action on this immediately, Mahler said. Mahler introduced legislation earlier this year to amend the third-degree sexual misconduct statutes to include language that says anyone who is intoxicated for any reason is unable to give consent. Quote, it makes it very clear that this issue needs to be fixed at the legislature, Lindsey Bryce, the law and policy director of the Minnesota Coalition Against Sexual Assault, said of the state's Supreme Court's Wednesday ruling. Marion O'Neill, a Republican state representative and co-sponsor of Mahler's bill, said that, quote, it is time now to pass these solutions so that no victim ever has to be denied justice over a technicality, end quote, in a statement. Minnesota is now among several states that only consider being drunk as a barrier to consent if the alcohol was given against the victim's will, according to the Washington Post. So now let me put this in layperson's terms because this is a big deal. If you and your friends decide you guys want to have a girls' night and get to drinking and carrying on, and later on that night someone rapes you, that person cannot be found guilty of sexually assaulting you because you voluntarily ingested alcohol. That's a big, big deal. Yes, they definitely need some clarification on this one because that would be, egregious. So I'm going to end the story on that note, but that is a huge deal. If I lived in Minnesota, I would be very scared. Thanks for watching, guys.